This is Mrs. Alexander, and this is your Activity 1.3.2 Confidentiality PowerPoint. Today we're going to talk about HIPAA. HIPAA is known for Health Insurance Portability and Accountability Act. You will need to know that acronym, so make sure you write it down and memorize it. HIPAA is a law that healthcare providers use when it comes to dealing with giving out privileged information about the patient. You need to know that it came into play in 1996, so that's when it started. Anything before 1996, HIPAA doesn't apply to. It has to do with electronic records, talking to patients, all sorts of things. It makes sure that federal privacy protections for individuals are given so that way their identifiable health information is not shared whenever it's not appropriate. You'll probably know of HIPAA whenever you go to the doctor and they'll ask your mom or your dad to sign off on a HIPAA waiver, or when you go to pick up a prescription, or when you turn 18, you'll be responsible for signing off on HIPAA. HIPAA, you need to know what it's about in order before you sign your name on that line. So what information is protected? Information such as your name, address, birth date, information about your physical and mental health, even if it was in the past, before 1996. If you're currently signing off on a HIPAA regulation, it's stating that all your healthcare information is protected. It also has to do with what kind of immunizations you get done or other healthcare services, like if you've gotten a test for strep throat or something, and also about the payments that you make for your medical records when it comes to past, present, or future payments for services that you've gotten done. The first lesson we're going to talk about today is how HIPAA protects patients and their personal health information, and how we can and can't disclose or give out that information. There are 4 rules or main purposes of HIPAA: privacy of health information, security of electronic records, administrative simplification, and insurance portability. Let's talk about rule number 1. How is your health information private? Well, there's detailed instructions for healthcare providers about how and when they can provide your information. We call the information about you PHI, Protected Health Information. Again, that talks about your name, your address, your birth date, the things we just discussed. This is why usually when you go to the doctor, you have to verify your name, your address, things like that. Or when you go pick up a prescription, if you're going to pick it up for someone else, you have to know certain details about them in order to get the information, like their birth date, their social security number, where they live. So understand that these pieces of information are protected. Nobody can just go in and get them. Rule number 2, or purpose number 2. To make sure electronic records are kept secure. We call this Electronic Medical Records, EMR. There are certain privacy issues that have been created to make sure that these are secure. There are 3 safeguards, or 3 ways that we keep them secure: physically, technically, and administratively. In recent years, there's been a trend in healthcare facilities to convert all medical records from paper to electronic. That's why there has to be some information about when and how we give out electronic medical records. Most of the time, if you've ever received an email from a healthcare provider or a doctor's office, there's a little disclosure or a little privacy tidbit at the bottom that says, "Note, this information is not to be shared, blah, blah, blah." So HIPAA provides regulations to make sure that those confidential records are kept secure. This is called the security rule. Under physical safeguards, this tells doctors, medical offices that the doors should be locked when it comes to before and after, and computer server rooms need to be locked, paper records need to be stored in locked, fireproof cabinets. You can't just throw them away, you have to shred them. Administration safeguards talk about policies must be in place regarding which employees have access. The janitor at a medical facility should not have access to your records. A doctor that you've not seen shouldn't have access to your medical records. You have to sign off saying, "I'm going to go to this new doctor. Please send them my records." All employees must complete a security training and background on HIPAA. You are probably not 18 if you're in my biomed course, and so therefore you completing a security training doesn't count because you're not 18. Therefore, you can't go around and observe certain places that have HIPAA rules, unfortunately. Now, when you get to the age of 18, you'll probably have to go through a HIPAA training or sign off something saying you understand what it's about if you're going to come and observe maybe a doctor or a chiropractor working. Under the technical safeguards, all medical records should be password protected. Usually it's your last word or social security. So whenever you get to be about 15, 16 years old and you start needing those numbers, keep that number very private and don't use it for all sorts of things. Whenever information is electronically transmitted, it needs to be encrypted, and so computers need to have some sort of antivirus software. Rule number 3, or main purpose, administrative simplification. Very simply, transactions and codes are set in rules. There's a national standard and simplified claims process. Because most healthcare agencies have adopted an electronic record system, there was a need for these standards so that health places all did it the same way. As a result of this rule, all medical transactions and codes have become the same nationwide. For example, a medical office assistant will be able to submit an insurance claim in the same format for any insurance plan and any insurance company. By standardizing these things, it makes it more simple. And rule number 4, health insurance access, portability, and renewability. Portability means portable, meaning you can take it from one doctor to the other. Access means that health insurance companies have access to your records when needed. And renewability means that you can go to the doctor and renew your healthcare information. So, when I had my son, I went in and let him know I had a child, and they updated my records. When a woman hits a certain age and she has to get a mammogram done, they update her records. This rule was created to make sure that continuous insurance coverage for people as they change or lose jobs. It also makes sure that it can be updated very easily and that they're not going to be denied in limited coverage for people who have pre-existing conditions. This brings us to when and how can our information be shared. This is the main purpose of this lesson you're going to be doing. You're going to be given scenarios. You're going to be asked, did these doctors or nurses violate HIPAA? Did they share information when they shouldn't have? Yes or no, and explain why. Privileged communication is information that's shared within a certain group of people depending on their relationship to the patient. They include between the doctor and the patient, an attorney and the client. So if you are needing to seek the help of a lawyer or attorney about something, then they have access to your medical records if it's medically related. And if the other prosecuting people, the clergy and counselee, need to use it to prove their case. Under most circumstances, privileged communication cannot be disclosed. Disclosed means given or told. So if I tell someone, yeah, they, had hepatitis when they were 12, then that's disclosing to someone. Relationships include the ones I just mentioned. For example, if an employee has taken a lot of sick days, the employer knows the employee's physician and asks the physician why the employee has taken so many sick days. That physician or that doctor cannot tell the person's boss without the patient or the person's permission. Professionals are to take all precautions necessary to keep all individual identifiable information confidential. For example, if you're in an elevator and you're talking from nurse to nurse about a patient that they share, and another person gets onto the elevator, you need to stop talking. Okay? And when it comes to talking about the patient, if you are not using any identifiable information and you're just randomly talking about a situation, then that's okay. But the minute that you use some sort of identifiable information, hair color, skin color, the name of the patient, when you saw them, then it's considered disclosure and you're breaking HIPAA rules. So professionals are not to speak about patients with any identifiable information other than other professionals working with the patient. So if you are in a doctor's office behind closed door and you go to one nurse and ask her about a patient that you share, you can share information. But the minute you're around somebody that has nothing to do with that patient, you're breaking rules. You should not leave public records in public open spaces that are unattended where they can be easily accessible to unauthorized people. That goes for teachers too. We have our HIPAA rules. We don't really call them HIPAA rules, but they're more the same kind of guidelines, but for teachers. We can't just leave a student's grade sheet on our desk, a grade card, open for anybody to look it over. This is also why we have to keep our certain records in the locked doors, so that way the janitors can't just come and peek. You must make sure, if you are in the healthcare field and you're a doctor or nurse, you must make sure you're making reasonable efforts to avoid being overheard by other people in the vicinity or in the general area when you're talking about a patient. This is why you go into closed doors, and doctors usually close the door behind them. Professionals may talk to or disclose your PHI, your protected health information, to a family member or other person, as long as the family member is present during the appointment or the disclosure. So a 30-year-old woman goes into the doctor and her husband's in there, and they're talking about the woman's, recent pregnancy test. Because the husband's in there, he can hear, and so if the husband calls and asks the doctor about something, he's able to disclose because he was there during the appointment. Rules are a little bit different if you're under the age of 18. Okay, so if you're under the age of 18 and your mom or dad's in the doctor's appointment with you, then they have all the ability to get information from the doctor. However, as an underage child, you are able to ask for your parent to leave, and if you ask your parent to leave during your medical exam, then your parent is not entitled to the information you share between your doctor and yourself. So if you wanted to ask the doctor a private question, your parent is not allowed to know what question you asked or what the answer was from the doctor. So note that that is something that is a little bit different when it comes to sharing or disclosing HIPAA or patient information. If you sign a waiver saying, yes, it's fine that my husband knows all this stuff even though he wasn't at my appointment, or you sign off something saying, my mom is the person that needs to handle this, please give her the information, it's okay for you to call and leave a message on my voicemail, that's usually what you're signing whenever you go to the doctor, saying it is okay that you're disclosing and you're calling my house and letting whoever knows pick up the phone the answer to the medical test or the medical question. So doctors are permitted to communicate with them as long as you give them consent. There are a few definitions I'd like to go over with you. The first one is, what is privacy? Privacy is defined as a patient's right to control the use of protected health information. Confidentiality is the using discretion when handling protected health information. So when patients have the right to privacy of their health information, and the health care employees have the responsibility to keep the patient's health confidential. Disclosure is being able to release, transfer, or provide access to your medical records, as we've talked about before. When can healthcare information be shared? Being shared whenever you need to make a payment to how much money you owe and when the services were taken care of. If somebody is trying to prevent some sort of serious threat to public health, like prevent an injury, control an infectious disease, or if there's some sort of child abuse, neglect, or domestic violence. For example, someone goes into the doctor and they find out they have HIV. That person will be asked to share information about previous partners so that they can inform those people, hey, you've contracted HIV from this person. So they can share your information with others if it has to do with infectious diseases. Legal proceedings having to do with court cases, your medical information is allowed to be shared with those, including law enforcement agencies having to locate or apprehend fugitives, identify missing persons or victims. Let's say a little boy gets lost and he is a diabetic. They will put on the news, this little boy's diabetic and he needs his medication if found. Any kind of person who is under the age of 18 must have a legal representative. That HIPAA information is shared with them. That's why if you're watching this and you're a student, your parents usually take care of the HIPAA for you. However, if you are over the age of 18 and you have been considered mentally ill, you also need a legal representative. So the mentally ill will also be allowed to share HIPAA information with their representative. If there's some sort of big disaster, tornado, earthquake, and missing persons are being looked for and they have some sort of medical thing going on, like again, diabetes or maybe has seizure, they can share that information with the news or the government agencies trying to find them about status and location. Once a person is dead, the coroners and medical examiners have access to all their previous medical records. Ownership of medical records, however, differs. You do not own your medical records. The facility that did the process or the medical exam does. You have the right to see and obtain a copy of your record, but they do not belong to you. Again, on the mental health illness, people with mental health issues do not have access to their medical records. The representative does. Why? Because sometimes this makes it worse for the patient. They think that they have something when they really don't. Schizophrenia, paranoia. If you are going to be employed by a future employer, they have access to obtain any medical records that they pay for. For example, you go in for a health screening to make sure you're physically fit, they have access to those records. And that is the end of our HIPAA presentation. Feel free to go back and take notes.